Ladies and gentlemen, boys and girls, it's Diego with another fantastic video for you out there in green card land, K1 visa land. This is not legal advice. I'm not an immigration attorney. I don't work for USCIS, but I have 13 years plus experience processing green cards and K1 visas. I can do it in my sleep, and I'm always keeping you up to date on what is the latest with immigration. I'm always keeping you up to date on what is going on in Washington, D.C. with USCIS. Now, pay attention, class, because USCIS Form I-485, the Adjustment of Status Form, is going to be changing on September 18th, 2026. It's going to be changing the whole format, okay? Now, this information is coming out of Washington, D.C., and out of the Department of Homeland Security, DHS. Now, they have issued a final ruling rescinding the 2022 Biden era regulation regarding public charge. Person is on welfare, basically. And this is further aligning the immigration law with congressional intent that aliens in the United States be self-reliant and not dependent on taxpayer-funded government benefits. Don't be dependent on my taxpayer money, ladies and gentlemen, boys and girls. Now, under the Immigration and Nationality Act, INA, an individual applying for a visa, admission into the United States, or adjustment of status will be inadmissible to the United States if they are deemed likely at any time to become a public charge. Very important you understand that. So the now rescinded Biden era regulation restricted which public benefits the Department of Homeland Security could consider, limiting officers' ability to review all relevant factors as intended by Congress. Now, Congress controls immigration, right? Now, with this final rule, USCIS officers are empowered to assess all pertinent facts on a case-by-case basis for each applicant. The Trump administration is upholding the rule of law and protecting American taxpayers from subsidizing aliens who may become dependent on public benefits, okay, welfare, etc. USCIS is committed to safeguarding the safety, security, and financial well-being of American citizens, said U.S. Citizenship and Immigration Services, USCIS spokesperson Zach Kaler put this memo out, and I'm the first ones usually to get these messages from USCIS, these letters. Now, the rule will take effect on September 18th, 2026. USCIS will publish a revised Form I-485, a brand new I-485 application to register permanent residence or adjust status. So the older versions, okay, of Form I-485 postmarked or submitted electronically on or after the effective date will not be accepted. So make sure you're going to use the correct edition date of USCIS Form I-485 after September 18th, or on September 18th or after. Now, this is a move that will place hundreds of thousands of green card applicants under broader scrutiny each year. The Trump administration is allowing immigration officers to consider whether some applicants have used taxpayer-funded benefits, including Medicaid, food stamps, and housing assistance, when determining whether they qualify for permanent legal status in the United States. Okay, so the change may directly affect hundreds of thousands of people who are applying for green cards from inside the United States, okay, each year, inside America, not outside. It could possibly trigger a broader ripple effect if immigrant families avoid health care, they avoid getting on food stamps or housing assistance, even when they or their U.S. citizen children legally qualify, out of fear, obviously, that tapping into these benefits could ultimately hurt their immigration case. Well, it will hurt your immigration case. The U.S. government is saying you got to stand on your own 2 feet in this country, not depend on taxpayers. Okay? Now, under existing federal immigration law, some individuals applying for a visa or admission to the United States or green cards can be deemed inadmissible if the government determines they are likely at any time to become a public charge. So make sure your income, Mr. American Citizen Sponsor, is way sufficient to cover your family size. Now, the Biden era rule, which was issued in 2022, limited the benefits the Department of Homeland Security could consider to primarily cash welfare payments meant to cover basic living expenses and long-term institutional care paid for by the federal government. Okay. This new final rule is going to restore the broader discretion that USCIS had during the first Trump administration so that officers can conduct case-by-case reviews that consider an applicant's age. How old are you, Mr. Beneficiary? Their health, their family status, their assets, their financial resources, their education level, and if they have any skills, and whether the person has received means-tested taxpayer-funded benefits. So if you're going to come to this country as a green card holder, married to an American, you better be bringing something with you that's going to benefit this country, or it's going to get harder and harder to get your green card approved. Now, if you receive like these benefits, which can include food stamps, Medicaid, and even housing assistance, according to USCIS officials, it could be creating problems for you trying to get your green card if you have accepted any of those things. The federal government is reaffirming the requirement of self-reliance, protecting public resources, and ending policies that encourage dependency on the backs of hardworking American taxpayers. Okay? Now, the USCIS Director Joseph B. Edlow told CBS News in a statement, under President Trump, USCIS is restoring the basic principle that immigrants must be able to support themselves. It's understandable, right? Okay, the rule applies to non-citizens inside the United States who are applying to adjust their status to lawful permanent residence, plus non-citizens seeking admission into the United States as immigrants, like those folks on those 75 countries currently blocked from getting green cards, or non-immigrants unless they fall into categories exempted by the U.S. Congress. Well, the U.S. Congress did not authorize the block on those 75 countries that I'm aware of, so that's going to get overturned eventually by immigration attorneys and federal judges. Now, historically, the public charge test exempts some refugees, asylum seekers, and those in humanitarian categories, including special immigrant juveniles, certain trafficking and crime victims, and Violence Against Women Act, VAWA, self-petitioners. Okay, now, in its November 2025 proposal, the Department of Homeland Security estimated that roughly 588,000 adjustment of status applicants each year would be subject to public charge review. Now, this is a figure, okay, that does not include all people applying for visas abroad or seeking admission at the border. But, the department has assessed that the broader impact could exceed formal assessments or practical denial. In this same proposal, the Department of Homeland Security has determined that changes to the public charge policy could create a chilling effect, leading about 950,000 people in immigrant households to disenroll from or forego public benefits altogether, which is the objective of the Trump administration, right? They want you to become self-sufficient and self-reliant, not dependent on American taxpayers. USCIS officials also told CBS News that benefits received by an applicant's family members will not be treated as the applicant's own, though officers may still consider them when assessing the applicant's finances. Now, you understand what they mean by that, right? The American citizen sponsor could be collecting welfare, and it shouldn't affect the beneficiary, only if the beneficiary accepts welfare. Now, there's an example right here. Though those benefits may factor in if they suggest the applicant cannot financially support the household, or if the benefits are helping to support the applicant. Once again, we're back to being self-reliant and self-sufficient. Now, the rule is expected to be filed for public inspection today, with its effective, with today's Thursday, July 16th, 2026, with its effective date slated for early next week. We're in July of 2026. But USCIS will not begin applying the new public charge framework for 60 days, giving the agency time to update the forms, the guidance, and internal procedures, and pushing the operational date into September, which is what I just said. The Form 485 is going to change in September. Now, for applications filed before the rule becomes operational, USCIS officials say they will only assess means-tested public benefits received on or after that date. What is that in other words? Well, in other words, benefits received before the program is operational will generally only be considered only if they included public cash assistance for income maintenance or long-term institutionalized care at the government's expense, the U.S. government's expense. So along with this final rule, USCIS plans to publish a revised Form I-485. Okay? Now, the application used by people seeking to register permanent residency or adjust status, they use that form, right? Now, older versions of the form postmarked or submitted electronically on or after the rule is operational will no longer be accepted. So pay attention, class. If you're fixing to file for a 2-year green card, AOS, adjustment of status with Form I-485, September 18th is when the form's going to change. Now, while the rule does not change exemptions established by Congress, USCIS says that these categories will continue to be listed on Form I-485 and in updated policy manual guidance, and questions will remain about exactly which benefits will count and what data sharing agreements the agency might use to verify benefits. And it also remains to be seen how the agency will train officers nationwide, that's USCIS, to apply the updated rule in a consistent fashion. So they don't want to be, it needs to be equal justice for everybody, right? But for those immigrants in the country right now and mixed status families, there's perhaps a more pressing calculation. The final rule could simply make food, health, and housing assistance feel too risky on the tenuous path to permanent legal status in the United States. Don't be dependent on the taxpayer of this country in order to hold a green card. What's going to happen is if you are dependent on public assistance, you are going to lose your status in the United States and be removed by an immigration judge. Stay updated, folks. This is the channel to be on. If you want to join the channel as a member, you can join down here as a member. It's $9.99 a month. And if you join as a member, you get my phone number and email address. You have to go into the members only videos to locate my phone number and email address. And I also do a live stream, mostly 3 times a week, but I'm maybe reducing it down to 2 times a week on Mondays, Wednesdays, and Saturdays at 6 p.m. Central. But I'm looking into perhaps changing the live stream to maybe just twice a week, Wednesdays and Saturdays. Thanks for watching the video, ladies and gentlemen, boys and girls. Stay patient during the process, and you will get your green card. You will get your K-1 visa approved, just so long as you qualify for the benefit, and just so long as you send overwhelming evidence to immigration to adjudicate your case and give the immigration officer 150% fuzzy good feelings that you are not going to become a public charge. See you at the next live stream.
Okay, I'll talk to you later. See you later. Bye.